Performance management versus constructive dismissal. When poor performance becomes illegal termination. Let's break down performance management versus constructive dismissal and clearly understand what performance management really is. Performance management is a legitimate management prerogative, but when mishandled, it can cross the line into constructive dismissal. Philippine labor law strongly protects employees' security of tenure, and employers must ensure that performance-related actions comply with both substantive and procedural due process. Legal framework, foundations of employee protection. Under Article 294, Security of Tenure, of the Labor Code, employees have the right to remain in their positions unless dismissed for just or authorized causes and only after due process. Articles 297 to 299 enumerate valid grounds for termination, such as serious misconduct, gross negligence, redundancy, or closure of business operations. This protection is reinforced by Section 3, Article 13 of the 1987 Philippine Constitution, which mandates state protection to labor. Employers are therefore duty-bound to respect employee rights during performance management processes. Before any case reaches the NLRC, Department Order No. 107-10 requires exhaustion of the single-entry approach, SEnA. All disputes involving performance management must first be filed as a request for assistance, RFA, with any DOLE regional office. The process has a 30 calendar day resolution period, extendable by 15 days. Failure to exhaust SEnA renders the case non-meritorious. What constitutes constructive dismissal? Constructive dismissal occurs when an employee is forced to resign because continued employment has become impossible, unreasonable, or unlikely due to the employer's acts or omissions. Common indicators include demotion without just cause, reduction in rank or title without performance justification, unilateral reduction of pay or benefits, denial of meaningful work, hostile treatment such as verbal abuse or discrimination, and unreasonable transfers. The Supreme Court test asks whether a reasonable person in the employee's position would have felt compelled to give up his position under the circumstances. Jurisprudential guidance in Tan Brothers Corporation of Basilan City versus Escudero, GR number 188711, 2013. The Supreme Court emphasized that constructive dismissal exists when employer actions effectively leave the employee with no real choice but to resign. Other indicators recognized by jurisprudence include forced resignation through threats, transfers to irrelevant or remote positions, and continued placement in situations that are humiliating or prejudicial. Common pitfalls in performance management. Legitimate performance management can turn illegal when employers fail to document performance issues and rely solely on verbal feedback. Skipping the notice and hearing process violates the twin notice rule and invalidates disciplinary action. Using vague performance standards such as poor attitude without specific examples deprives employees of fair notice. Retrospective evaluations based on outdated performance data undermine fairness, while inconsistent application of standards exposes employers to discrimination and constructive dismissal claims. Real-world cases. In Philippine American Life versus Gramaje, GR number 156963, 2004, a senior lawyer was transferred to a role that was unreasonable and prejudicial, with the employer even advertising for a replacement before finalizing the transfer. The court ruled that the transfer amounted to constructive dismissal due to bad faith and discrimination. In Teles International Philippines versus de Guzman, GR number 202676, 2019, an employee was placed on floating status without work, despite being cleared of misconduct. The court held that the employer's failure to reinstate the employee and the creation of unbearable working conditions constituted constructive dismissal. Escalation process. From complaint to NLRC. The process begins with SEnA conciliation through an RFA filed with DOL. If no settlement is reached, DOL issues a certificate of non-settlement, which allows the employee to file a verified complaint with the NLRC within 30 days. After filing, mandatory conciliation mediation conferences are conducted, followed by submission of position papers. Decisions are issued within 30 days from the last position paper and become final if not appealed within 10 days. Appeals may proceed to the NLRC Commission, the Court of Appeals, and ultimately the Supreme Court under limited grounds. Remedies and consequences for employers. When constructive dismissal is proven, employees may be entitled to reinstatement without loss of seniority rights, full back wages including allowances and benefits, or separation pay in lieu of reinstatement. Courts may also award moral and exemplary damages when bad faith or harassment is present, as well as attorney's fees equivalent to 10% of the total monetary award. Best practices for HR professionals. HR professionals should document all performance issues using specific and measurable criteria and strictly follow due process, including the twin notice rule and a minimum 5-day response period. Performance improvement plans should be clear, time-bound, and properly acknowledged by employees. Employers must avoid unilateral changes to job duties, salary, benefits, or work location, and ensure that transfers are justified, reasonable, and not prejudicial. Regular training for managers and HR staff on labor law and constructive dismissal risks is essential. Key takeaway: by embedding sound performance management practices and strict compliance with labor laws, HR professionals can maintain accountability while protecting employee rights, preventing disputes before they arise. Thank you for watching. I hope you learned something and that this left you with a valuable lesson. Again, this is your HR at your service. Enjoy HR Tambayan community. Please follow, share, like, and subscribe.